Julie, you still there?
I am.
Okay, good. So now we're live. People will start entering the room. I don't think anyone's had time to get in yet. Julie, you can still see the slide.
Yes, I can.
The chat room should be working.
Oh, yep, I see it. I was on attendees, sorry.
Okay, and I see some people are logging in now. So hello, as you're joining us, thank you. We'll get started in a couple minutes. We just gotta give everybody a chance to get logged in. I'm Scott Horton. Julie Bastian is also joining me for this webinar.
Hello, sorry.
So it looks like the chat is working for some of you. So as you're joining, if you can hear me, if you can't hear me, it doesn't matter what I say because you won't hear it anyway. But if you can hear me and see the cover slide, Reopening New York Part 3, and have access to the chat window, you should be all set. We'll use the chat to take questions. I'll go over that more in a couple minutes when we get started. As you're joining, just know that as we typically do, we will aim to limit this to about an hour, but then we will stay on to answer questions at the end as long as there are questions. Also, I'll repeat all this when we officially get started in a couple minutes once everybody's had a chance to log in, but the slides will be available at the end of the presentation. So just the people who are joining know we are here. I'm Scott Horton. Julie Bastian is also with me. We're going to get started in just a couple of minutes. We still have people getting logged in to the room, so we want to give everyone a chance to do that. Julie, you want to say hello just to make sure everyone can still hear you as well?
Sure. Good afternoon, everybody. How's everybody doing?
I'm going to give about 2 more minutes. We're about at our scheduled start time, but I just want to make sure everyone has a chance to get logged in. I know I opened the room a couple minutes later than I normally like to. So again, we're about to get started. If you have the slide Reopening New York Part 3 Back to School Edition in front of you and can hear us and have access to the chat window, then you're all set. We will get going in just a moment. Just a reminder that if you do have any trouble at any point during the webinar, you can try logging out and logging back in. But before you do that, maybe try closing any other apps you have going that might be slowing down your computer, because sometimes that is a little bit of an issue for folks. All right, I'm going to go ahead and get us started. Again, I'm Scott Horton, joined by Julie Bastian. Julie, you want to say hello?
Hello, everybody.
So our presentation today is the third in our series on reopening New York. We're calling this the Back to School edition because we are approaching that time of year where normally kids will be going back to school. That's going to look a little different this year, just like virtually everything else. So we want to give a perspective on what employers should expect with the schools reopening, such as it will be throughout New York. But it's not just going to be talking about schools. We're going to use that as the basis to talk about the various leave laws that are out there, both how those might apply for employees who do have children in school, or I should say that are not physically at school because of the coronavirus situation, and employees may be seeking accommodations, whether that be working from home or something else. So we're going to talk about some of those laws. We'll talk about some of the latest updates generally that affect employers in New York, and we will hope to tie it all together. And I will talk later about what we anticipate possibly being our next webinar. It may not be one of these reopening webinars after this, but of course we will continue to track and monitor everything that might be of interest and put it together and share it as we can. With that being said, we already have a question in the chat room. A familiar attendee knows to go ahead and get those questions in when they come up, but we will probably wait and answer the questions at the end of the presentation. If we happen to see a question that we can address as we're going, we will do that, but for the most part, we will try to get through our presentation in about an hour and then answer the questions at the end and stay on as long as it takes to answer any questions that there are. I just know, again, that when you're asking questions, keep in mind that other people may be able to see your name or the details of the question, and there's no attorney-client privilege in this format, so don't ask anything that you're not comfortable with other people seeing the answer and or the question and or hearing the answer. I will try to remind everyone of that at the end as well. If you do have a question that is more specific to your business and you need confidentiality, then you can contact us separately after the fact. With that, I'm going to go ahead and get going with our content. I just first want to recap where we've been from the two previous reopening New York webinars that we've done. We talked a lot about the 4 phases of reopening in New York and what that meant for different businesses. We are now in phase 4 throughout the state of New York. There are no further stages scheduled at this point. What may yet come is, as far as we know now, going to be ad hoc. Just a note on that is, while all of the phases have been triggered everywhere at this point, that does not mean that every business, of course, is just open to do everything the way they used to do it. The Department of Health has reopening guidelines that businesses must follow in numerous industries. I think maybe about 40 different industries, and some of those are pretty generic, like office work. So you, of course, need to make sure your business is following those guidelines, but it's also important to know that the Department of Health periodically updates those guidelines. So you need to track any changes and review them to make sure that you are still compliant. There are now nationwide across the United States over 5 million confirmed COVID-19 cases, and of course rising by the day. While at the beginning of all this, New York State and New York City in particular were rather high in those cases, and the extreme outlier in the negative sense there. We have now gotten to a point where approximately half of the 50 states have had more cases come up in the past week than New York has. That despite the fact that New York has the 4th highest population. I was looking for some per capita numbers over the last week, but I couldn't really find that data easily. But I think that point makes it clear that New York is doing much better than other states, but there are still, a couple thousand new cases in New York over the past week. So we haven't dropped to 0. I think it might be about 4,000 statewide, about half of those in New York City and half of them throughout the rest of the state. But other states have had tens of thousands of cases over that time period at this point, and that's caused some changes that we are going to talk about today, including some of the travel restrictions and what that means for employers as well. Of course, unfortunately, going backwards is still a possibility. We've seen other states turn in the negative direction, and what obviously New York does not want to have happen is a major uptick in its cases. There is some concern and question about what's going to happen when schools reopen, and that is part of what we're going to try to address today. Again, here is the statewide map now with the 4 phases otherwise being shown, but everyone is in phase 4. Again, if you didn't hear it up front, all these slides will be made available to you at the end. Just a little recap, the 4 phases started with construction, agriculture, curbside retail, manufacturing, and some wholesale trade. Phase 2 shifted into office workplaces being allowed to open, some additional food service being addressed, hair salons starting to come online, and some in-store retail. Phase 3 opened up the restaurants more broadly and extended personal care, including hair salons, beauty shops, tattoo parlors, tanning salons. And then phase 4 includes education, both pre-K through 12 and higher education, certain low-risk indoor and outdoor entertainment, media production, professional sports with no fans, which is happening now across the state. I think it was Tuesday of this week was the first time in over 100 years that 3 Major League Baseball games were being held in 3 different cities in New York in the same day, with Buffalo now hosting the Toronto Blue Jays, and the Yankees and Mets also had home games on Tuesday. But of course, with no fans, or at least no actual fans, they have cardboard cutouts, which some of you may have seen, but they don't seem to pose much of a COVID transmission risk. And the malls are allowed to open in phase 4 with some restrictions, including enhanced ventilation requirements. There are some statewide guidelines that have come up. So some other industries were allowed to open, not specifically tied to one of the phases. These include dentists, for example, public transportation, professional sport and training facilities, in order to allow those teams to eventually get back on the field with no fans. They first had to allow the teams to start training in person. So there were some industries that were not tied to a particular phase. And despite being in phase 4 with no phases yet to come, New York is still not allowing certain businesses to reopen. Primarily notable among those are gyms, movie theaters, bowling alleys, certain other inside entertainment venues. Broadway, for example, theaters are closed, I believe, through at least the end of the year. Indoor dining in New York City was put on hold, even though indoor dining was generally through the rest of the state in phase 3. Particular concerns in New York City led the governor to shut down indoor dining there. So these are industries that are really on hold. They don't know when they're going to be allowed to reopen. Understandably, they're not very happy about it. If you own a gym or a movie theater, you have limited options. Drive-in movies are permitted, but the in-person go inside and sit down movie theaters are not open. And unfortunately, those are businesses that don't have much of an alternative business model. However, I did drive by one the other day where they were open for popcorn sales. So they could have takeaway popcorn. I didn't go in to check it out. Maybe they have some gourmet popcorns available, but gyms have been able, for example, to do a little bit of remote training and stuff like that. But, you know, movie theaters, bowling alleys don't have great alternatives to in-person business. And again, with the restaurants in New York City, they can at least do takeout business and delivery. Just some final reminders for businesses that are open. You need to be complying with New York State Department of Health guidance. This Department of Health guidance is essentially Governor Cuomo's directives through the Department of Health. So it, you know, when he talks about standards, he's generally talking about standards put out by his Department of Health. Those need to be reviewed and complied with to have your business open. There's also CDC guidance that addresses some best practices and guidelines for social distancing, cleaning, disinfecting. And in many cases, the Department of Health guidelines reference the CDC guidance and require employers to affirm not only that they're complying with the Department of Health guidance, but also that they're complying with applicable CDC guidance. OSHA also has information available. OSHA has not taken a extensively restrictive view on workplaces for the most part, but certain industries, you've seen the cases of meatpacking plants, for example, and other settings where people work close together and there have been larger outbreaks. Their OSHA guidelines would be potentially more important to follow. Certainly, you should always follow the guidelines that apply, but as far as COVID specific, other just tips for employers at this point, most companies are well served to be constantly educating employees on what safety precautions are expected and what safety precautions are being taken. You want to make sure that employees feel safe so they can be productive while at work. There's no reason you're not notifying staff of positive cases at this point. The local health departments need to do contact tracing anyway, but you know, you want to have open lines of communication to the extent you can. That doesn't mean you can necessarily tell employees who tested positive, but if they might have been exposed, then it's more important to make sure they get tested and get the positive treatment than it would be to try to hide that out of fear of liability, for example. And, you know, unfortunately, it's not easy to do, but employers need to be staying aware of changes in CDC, Department of Health, OSHA, Department of Labor, and other changes in guidance and regulation that might be relevant to their particular business. We're going to talk about some of that as we have in other webinars, but there are so many details that depend so much on how particular businesses operate that, of course, we can't explain all of it in this format. And with that, we're going to move into some of the particular guidelines and the travel restrictions are the first thing we're going to tackle, and I'm going to switch it over to Julie to do that.
Okay. So we included travel restrictions on our webinar because it's definitely something that has an impact on businesses in New York. On effective June 25th, 2020, Governor Cuomo passed an executive order that restricts travelers from coming into the state restricts travelers coming from a state with a significant COVID transmission rate. Those individuals that come from a restricted state have to have a mandatory 14-day period of quarantine. the list of, first of all, the reason why the state becomes a restricted state is because they have a positive test rate higher than 10 per 1,000 residents over a 7-day rolling average, or they have a testing positivity rate of higher than 10% over a 7-day rolling average. We started out with only a few states, and that list has grown significantly. So that list of, I included the link here for the list of restricted states, just so you can make sure that you're checking that before you have anybody that is required to travel for business or anyone that travels for personal reasons. So for anyone that does travel out of state to one of those restricted areas, they have to complete a traveler health form when they come back into New York. And the idea is you're, registering, notifying New York that you have gone to one of these restricted states and identifying the information, kind of where you're staying, and acknowledging that you'll do a 14-day quarantine period. There's a $2,000 fee for non-compliance with that 14-day quarantine period and completion of that traveler health form. There are some limited exemptions to these travel restrictions. For somebody who is kind of just passing through a state and their time within that restricted state is less than 24 hours, even though it says less than 24 hours, it's really limited to those, you're traveling by plane, you stop at, your layover, you're ready to get onto another plane to come home, and unfortunately, that layover happened to be in one of those restricted states. But it also applies to rest stops for vehicles, buses, or trains, and any other layovers that you might have, as long as it's less than 24 hours. We also have an exemption for essential workers. So there's a list of essential workers that have been allowed to continue to work, since since businesses were restricted, back in March. And those requirements vary, obviously, based on the time the essential worker is in New York State. So all of those essential workers are covered under those travel restriction exemption. The individual employed by an entity included on that essential business list. So if you work for the company and it's considered an essential company, any employee under that would also be covered. I don't know why they go into specifics, but if you're employed as a healthcare worker, first responder, work in a nursing home, long-term care facility, any of those individuals otherwise mentioned in the essential workers list are also covered. And that includes those coming into New York and those leaving New York. So if you're going to work in another state to help them out, you're an essential worker and you go to another state, or you're coming back home, or one of these people are coming into New York State from a restricted state. You can apply for another exemption through the Commissioner of Health if there's a specific situation where you don't want to have to be quarantined for that 14-day. These essential workers, they still have to comply with certain restrictions. They want to make sure you're limiting your access to anyone else, staying home and in quarantine as much as possible. But if you do have to go back to work, you have to make sure that you're wearing protective gear and following all of the guidelines that are out there for those essential workers that travel to a restricted state. So when it comes to employers, it's definitely recommended that you limit non-essential domestic and international travel to the extent possible. The last thing you want is that coming back on you as the employer, forcing them to go to one of those restricted states or countries, whatever it might be. To the extent you can, it's recommended that you continue to use video conferencing and teleconferencing, for client meetings, for internal meetings, any type of gathering, trainings, rather than have those individuals travel for business purposes. For those of you that do require business travel, it's recommended that you have an essential business travel policy that covers the situation, that covers the period of the pandemic. So what type of extra PPE are you required to have? Do you have any restrictions on where they can go, where they can stay, what they can do when they're in those restricted states? You want to make sure that anyone traveling for business is conducting a health screening before they meet with anybody, before they go, and a temperature check. You want to do that before and after the travel, and of course, reporting that any signs of symptoms to the employer, or getting that checked out after they return home. In that policy, you want to make sure that you're outlining the rules for social distancing, any personal protective equipment that they should be wearing, any cleaning, sanitizing, and disinfection that should be done, whether it be the person, any equipment that's being used, or the area where they're meeting. And then lastly, that notification requirement. If something does go wrong, who should they be notifying? If they have symptoms, who should they notify? If they've tested positive, who should they notify? You want to make sure that you're checking the CDC's traveler health notices, and there's both there's restricted states, or those that they identify as level 2 or level 3 through the CDC of where they do not recommend that you go, and then also New York's list of restricted states. So you want to check both of those areas when having individuals go for business travel. And then, of course, we get into, will schools reopen in September? I know this is a question that many businesses are grappling with now, what they should do, how do they deal with employees, and so we're here to kind of give you an overview of what's going on. So back to school, and this applies to both anyone from pre-K to grade 12 and both public and private employers. Will these schools reopen? If they reopen, will it be in-person learning or remote learning? And how does this ultimately impact your business? Those are hopefully the things that we want to address here. So as of August 7th, Governor Cuomo has announced that schools are able to reopen in September, assuming that they satisfy the New York State Department of Education and Department of Health guidelines. And those set forth a number of things: personal protective equipment, social distancing guidelines, cleaning, disinfecting and sanitizing guidelines, testing, a number of things that each school district had to comply with in order to reopen. He acknowledges that there's no one-size-fits-all plan, same with the Department of Education. And he has basically left it up to the schools, up to their discretion on how they put together the reopening plan and what type of model that they use if they have to go to a hybrid model. And we'll get into those details. So we're seeing 3 types of plans: the in-person model, hybrid model, or virtual remote model. And school districts, anyone in New York, any school district in New York they had to come up with 3 different plans. And the idea was that at any point in time during the school year, they might be required to fluctuate between, plan 1, 2, or 3. And they might even need to start out, and maybe they're not going to start out in person, but they're going to start out in hybrid model, but they need to be prepared to address all of those models. So for the in-person model, that's going to have 100% of students returning back to school for in-person learning. In order to do that, the districts have to follow the CDC education guidelines and the Department of Health guidelines. And there's quite a few of those that they have to make sure that they're putting in place and are prepared to address once those students come back into the school. I think this is a more convenient option for employers because all the children are back in school full time, except for the fact that it will most likely ultimately lead to the transmission of virus into the workplace. Because if those kids are going back to school and they're transmitting or they're carrying that virus, they're going to most likely bring it back to the adults, and now the risk has now increased of transmission in the workplace. But in terms of having to possibly accommodate the parents' schedule based on where the children are during the day. If those kids are in school, it's likely that those parents can come back to work. So under this model, employers will need a plan to address employee requests for time off. It could be for a voluntary quarantine of a parent or child, a mandatory quarantine of a parent or child, or even just because a student gets sent home with symptoms or has a fever, and the parent has to, go retrieve that child. I don't think I mentioned this before, but just the reason this makes it even more complicated is every school has discretion to set up their own plans. Those plans can vary by, their elementary school, their intermediate school, and secondary school. All of them can be different, and then every school district may be different. So to the extent that you have employees from all over in different school districts, the needs of those employees are going to vary. And that gets more complicated with the hybrid model. So here, the students get split into cohorts and alternate between in-person and remote learning. Some examples that we've seen, you have cohort A and cohort B. Cohort A comes to school on Monday and Tuesday, and cohort B comes to school on Thursday and Friday with a deep cleaning on Wednesday. And on the days that they're not in school, they're learning remote from home. So other models are Monday, Wednesday, Tuesday, Thursday, or some have gone to attending in person one full week for cohort A, and then the next week it'll be cohort B, making it easier to handle the cleaning and disinfecting requirements that are set forth by the Department of Health. So under this hybrid model, you can see why employees with school-age children will need to make childcare arrangements on those days when the children are learning remote. And that's going to vary based on what school district they go to, or even what school within the district they attend. I think I addressed that. And so for employers, the idea is that we want you to be aware of what's going on, because likely employees are going to come and request for some type of an accommodation to their schedule, or request to work from home, any way to accommodate these unusual circumstances for both parties. Then there's the remote models, the third plan. And this has 100% of students participating in remote learning. If you pay attention to the news, we've got a number of school districts that originally planned to be in person or in a hybrid model that are now converting to a remote model, just given all the restrictions that they have to comply with. They've just determined that it was impossible for them to meet those guidelines by September, so they're moving to at least starting off with a remote model. The remote model has to be offered anyways to high-risk students or students with high-risk family members. The risk of them being in person is increased, so districts have to offer them an option for 100% remote learning. And then there's also an option for just parents that don't feel comfortable having their child return. So they may not be high risk, or they might not have a family member that's high risk, but the parent just really isn't comfortable yet with the restrictions that have been in place, that have put in place by the district, or just believing in their overall safety once they return to school. So for those parents, they have an option to participate in 100% remote learning as well. So for employers, this means anyone with school-age children that's attending school, attending remote learning, may seek accommodation requests related to childcare. Obviously, that seems to be more appropriate for employees with younger children. But I mean, depending on the child and the circumstances, it could be anyone from pre-K through 12. One thing employers need to be careful of is, while you're, granting or considering these accommodation requests, you want to make sure that you're not discriminating against any employee, whether they have children or don't have school-age children. It's a complicated matter, but it's something you always want to keep in the back of your head. And just kind of giving you food for thought, some of the back to school issues that businesses need to consider. Will you allow employees to continue working remote? Is it possible to come up with some flexible or alternating schedules for those employees who have children at home that are participating in remote learning, or even that hybrid model? If not, is it possible to do some job restructuring or making some accommodations to a certain position so that they can work remote or work a different schedule? And it's not exactly the best case scenario, but in order to keep your workforce going and your business going, these are some of the things that I think it's necessary to start considering. The one thing we recommend is that you take proactive measures. Don't wait until the very last minute, because you're going to be bombarded with these requests. Some companies might want to release a survey in advance asking those employees that are going to need accommodations, or just start having your supervisors talk to their staff. Any education or resources that you have for employees that are faced with these difficult challenges would be great. Some employers are turning to their EAP programs, whether it be for childcare. We've even seen some businesses create a childcare facility within their office. And then just, common sense, kind of being supportive and understanding. I mean, nobody planned for this, but unfortunately, there are a number of people that are stuck in this scenario, and, we have to make the best of it. Again, if you want to make sure that whatever you're doing, you want to be consistent with how you apply these policies to avoid any kind of discrimination claims by employees. Let's see. And then now we're going to get to these paid leave laws. Scott, was there anything else you wanted to cover in that section?
No, I think that gives us a good background. So again, if you have specific questions related to the schools, you can certainly ask those, and we will be happy to address them at the end. But what we kind of wanted to do is use that as a jumping off point into discussing some of the now many leave laws that might be implicated, either based on employees needing time off because their kids are not in school, or just employees who need time off somehow related to coronavirus, one way or the other. So with that background, there are some paid leave laws that could apply. There are some additional unpaid leave laws that may apply, and it is getting to the point where, as I told Julie earlier, you start to wonder whether there's going to be a whole new practice of law just limited to employee leave laws, because it is very complex and particularly difficult for businesses to try to anticipate how they're going to deal with all of this state and federal regulation that is coming fast and furious. But we're going to do the best we can to give you a general overview of that, so you at least know what you're looking for as these issues come up. This is not the first you've heard probably of any of these laws. We'll try to present them together so you can see how you need to work through the different steps of the analysis. So the paid leave laws right now, relevant to New York anyway, include the Federal Families First Coronavirus Response Act, or FFCRA, which included an emergency paid sick leave law and a paid Family Medical Leave Act component. We'll go into more detail on those. There was a New York State quarantine leave law. That's not an official name, but that's what I call it to try to avoid complication with all the other laws that are out there. And then there is coming up a new New York paid sick leave. This is a state paid sick leave law in New York. New York City already has a paid sick leave law, and I'm not going to go into detail on that existing law, primarily based on Most of our attendees are not in New York City, or primarily not in New York City. But if you are, you should already be familiar with the New York City leave law. That'll just be something else you have to integrate with all of the forthcoming requirements under the New York State paid sick leave law. Although I think the state sick leave law is generally designed to where it can simultaneously meet the New York City requirements. So starting out with this Families First Coronavirus, what was it called? Response Act coverage issues. Who does this apply to? It applies to all state and local government employers. So that would be cities, towns, school districts, public authorities, for example, of any size. And then private employers with less than 500 employees. This is one of these unusual circumstances where something applies only to smaller employees and not larger employees. Why is that the case? Maybe a combination of political reasons, but among other things, this paid leave is going to be paid ultimately by the federal government through the form of tax credits. So allowing larger employers to be part of this system would just be more costly. And the assumption was that hopefully the larger companies are already providing some form of paid leave. And then it is also worth noting that generally these leaves are available for employees who are unable to work or telework for their covered reasons under the statutes. So somebody who can work at home probably is not entitled to be paid to not work. And I'll go into that in more detail. So what are we looking at more specifically? We're looking at a combination of what's called an emergency paid sick leave law and a new FMLA leave circumstance. This whole law, this FFCRA, with respect to these leaves anyway, only applies through the end of 2020. So these laws expire December 31st, 2020. When this law was passed earlier this year, I don't think anybody really expected it to be relevant beyond that point. Everyone was assuming that this was all going to be behind us by the end of the year. So it does sunset. That's not to say Congress couldn't at some point in time step in. Right now, it doesn't look like Congress is capable of doing much of anything, to be frank. And there's an election, of course, coming in November that will impact what Congress can do beginning January of next year. But for now, what it does is allows 2 weeks of paid sick leave, and that is paid either at the employee's regular rate of pay if they're unable to work due to their own health concerns related to coronavirus, or paid at 2/3 the employee's regular rate of pay if they need to care for a dependent, a child, for example, who is under a quarantine order, or a child who needs a parent to care for them because their school or daycare is closed. There's then an additional 10 weeks of paid leave potentially available under the FMLA only for the case of a parent who needs to care for a child whose school or daycare or childcare arrangement is unavailable due to COVID-19. The FMLA leave would actually run simultaneously with the paid leave for the first 2 weeks. So it starts at the same time, if applicable, to the paid sick leave law, but the first 2 weeks of that FMLA leave remain unpaid under the FMLA. They're paid under the separate emergency sick leave law, and then up to 10 additional weeks. The last 10 out of 12 weeks of FMLA availability would be paid at 2/3 the employee's regular rate of pay. Again, only if the leave is to care for a child whose school is closed. We weren't, exactly sure how that was going to look this fall for various reasons, but now it certainly appears that there will be employees whose children will be home from school. And even if they're home a couple of days a week under a hybrid model, it's likely that employees would have the right to take this time off if they are otherwise eligible to watch their children. So that is going to become an issue for many employers. And remember, these apply to all employers with less than 500 employees. So while the FMLA generally applies to employers basically with at least 50 employees, smaller employers can be subject to this new FMLA paid leave requirement, except there is also a potential exemption for small businesses with less than 50 employees, but you have to take an analysis of your workplace at the time to determine that it would not be feasible to let this person be off work. So if you are under 50 employees, that's a possible exclusion, but you need to think that through. The other note here is all of this compensation under these provisions is ultimately subject to a payroll tax credit, so that the government should be paying for it ultimately, not the employer. So there are cases where it would be in the employer's interest to have these apply, especially if the employee is not going to be at work anyway. Again, we can't get into all the details on all these laws right now, but I wanted to give as much detail as I could on those two laws. And what I should clarify is there's a further list of what exactly qualifies someone to take the leaves. It's basically 6 different criteria, half of which are related to the employee's own situation. They're subject to a quarantine or isolation order. Their doctor has encouraged them to self-quarantine, or they're experiencing coronavirus symptoms. There's also coverage for employees who are caring for someone who is on a quarantine order, or as mentioned, caring for a son or daughter whose school or daycare is closed. There's also some possible other situation where an employee is experiencing any other substantially similar condition. At this point, I'm not aware of anything that's been really identified to fit into that category. But again, if it's because of the employee's own health situation, it's fully paid for 2 weeks. If it's because of a child health situation, then it's only paid at 2/3. And that's for 2 weeks under one law, and then the next 10 up to 10 weeks under the new paid family leave. All right, now set that all aside. Around the same time, might have actually been the same day, New York State came out with a quarantine leave law, which applies to all New York employers, public and private, of any size, except that the employee benefits available technically vary based on the size of the business. So smaller businesses don't have to pay the employees. They just have to let them take the time off. That's employers with less than 10 employees and income less than $1 million. And then there's a medium category of employers with more than 10 employees and a net income of greater than $1 million, or between 11 and 99 employees, who have to provide 5 days of paid leave. And then the largest employers with over 100 employees have to provide at least 14 days of paid sick leave. And public employers of any size have to give 14 days of paid sick leave. But just a note on that, the pay can then be supplemented further under the New York Paid Family Leave Law or Disability Benefits Law. It gets fairly complex, but basically the employee might be able to get up to full wage replacement, even though the employer is not paying for all of it. This leave, though, is limited to situations where employees are unable to work because of government-issued quarantine or isolation orders. So it's not as broad as the federal laws we just talked about, and it does not cover or address the situation where schools are closed. If a child is home because they are quarantined, then the parent may be able to take time off under the New York paid family leave law to watch them. But if the child is just home because school is closed, New York law does not require employees to let that, or does not require employers to let that employee stay at home. I'm going to go through this pretty quick. There has to be a mandatory order of quarantine or isolation, or a precautionary order of quarantine or isolation. But for the most part, there actually has to be a government entity that issued the quarantine order. There's a limited scenario where a treating physician can provide the documentation in the interim if the Department of Health is not responding fast enough. However, for the most part, I think the Department of Health is responding fast enough to get these orders. And then again, there's an exception where if the employee is not sick but quarantined based on exposure to someone, or they have tested positive but are asymptomatic, and they're able to and are allowed to work remotely, then you don't have to give them the 2 weeks off. And once their quarantine or isolation order is over, they're not entitled to further leave, even if they hadn't had the full 2 weeks off. And there's also a caveat for employees who knowingly traveled to either a country designated by the CDC as having a heightened level of COVID-19 cases, or a U.S. state, which is now the overwhelming majority of U.S. states considered to have a high positive test rate. Employees who knowingly go to those places are not eligible for paid leave during their quarantine when they return. However, they are still entitled to take the 2 weeks off of work just without pay. Okay, so that was the New York quarantine leave, relatively limited application. Before that was federal leave laws with broader application for employers under 500 employees or for public employers. We now have in New York, coming up technically at the start of next month, a new statewide paid sick leave that, although it could apply in COVID cases, is not specific to coronavirus in any way, nor is it limited to the duration of the coronavirus pandemic. It is just a new permanent paid sick leave that applies generally throughout the state of New York. The law technically takes effect September 30th, 2020, so at the end of next month, and employees begin to accrue sick leave at that point in time, or new employees once they are hired after that. No employee is allowed to take this leave under the law until January 1st of 2021. So they wrote the law in such a way that employees would start accruing leave basically in October, November, and December. So they would then have leave available as soon as 2021 came around. The leave has to accrue at the rate of not less than 1 hour per 30 hours worked. So an employee who worked 30 hours a week, for example, to keep the math easy, would accrue an hour per week. And that means if there's roughly 12 or 13 weeks left in the year after September 30th, that person would have, say 12 hours of leave available come January 21st. The amount of the ultimate total amount of paid sick leave available to any employee depends on the size of the employer. I'll get to that in just a second. I will just note that employers don't have to do the accrual model. They could just give it to you give it to employees all at once. So for example, you could just give employees their full annual allotment beginning January 1st, 2021, in which case, if that was the approach you chose, you wouldn't need to worry too much about the accrual beginning September 30th. But if you are going to use the accrual method, make sure you start doing it by September 30th. You're going to need a plan, a written plan in place, a written policy of how this is going to work, and get that to employees. Right now, what we're waiting on is regulations from the New York State Department of Labor. Hopefully, we will get those relatively soon. My expectation is if those do come out with enough time, we will try to do a webinar next month on those regulations and the New York paid sick leave. There are a lot of nuances, and we will go into that in more detail if we have the regulations out. Just quickly, it's either 40 hours annually or 56 hours annually for full-time employees, prorated for part-time employees, and it's a similar number of employee threshold as we talked about earlier for the New York coronavirus sick leave. So if you have less than 5 employees and income under $1 million, it's 40 hours of actually unpaid sick leave. So while it's called the New York paid sick leave law, there is a component of it that's only unpaid. But once you get above 5 employees or $1 million, it becomes paid sick leave, and it's 40 hours up to 100 employees. Once you're at 100 plus employees, you have to allow 56 hours of paid leave each year. And note, this is not a government paid benefit. This is an employer paid leave. Just to be clear, this New York paid sick leave is available for absences related to mental or physical illness of either an employee or the employee's family member. And regardless of whether the injury, illness, or health condition has been diagnosed or requires medical care at the time the leave is requested. So this is much broader and open-ended than the federal FMLA. The diagnosis, care, treatment of a mental or physical illness or need for medical diagnosis or preventative care for an employee or employee's own family member. So even if you haven't been diagnosed yet and don't know whether you have an injury or illness, you're entitled to leave to figure that out. And it also includes, although it doesn't really have anything to do with being sick, hopefully in most cases, or at least necessarily doesn't, it also allows for absences related to domestic violence. So that means generally victims of domestic violence, of course, not someone who is alleged to have perpetrated domestic violence. Okay, so those are the paid leave laws that are online in New York and coming online. Unpaid leave laws that we can't forget about are the Family and Medical Leave Act, of course, primarily, and then the Americans with Disabilities Act and New York State human rights law, as well as New York City human rights law, which all require accommodations for people with disabilities, which in some cases could include leave. So the laws don't address leave specifically, but they require reasonable accommodations in certain situations, and those accommodations might include unpaid leave. Theoretically, they could include paid leave too, but again, the laws wouldn't expect or require employers to pay employees to be out of work to accommodate their disability. For the FMLA, it does a lot of things, and we talked about the new special provisions for the rest of this year for caring for a child that are partially paid, but the FMLA that's been around for much longer now, that employees of companies with over 50 employees might be eligible for, are allowed to take unpaid leave for up to 12 weeks a year, including to care for their own health condition that prevents them from being able to perform the essential functions of their job, or for their spouse, child, or parent's serious health condition. So those are the aspects that could apply. There's also military leave provisions, but those are less likely to be triggered by the day-to-day coronavirus issues that we expect employers to see. So here are some thoughts on the FMLA and COVID-19. First of all, the Department of Labor has made clear that an employee with a serious health condition cannot take FMLA solely to avoid exposure to COVID-19. In other words, just because they have a serious health condition, and even though they might believe that the serious health condition might make them more susceptible to COVID-19, they don't have the right to take FMLA leave solely for the purpose of avoiding COVID exposure. However, it would cover an employee with a serious health condition, or an employee who needs to care for a covered family member with a serious health condition, under the same circumstances that it always would. So if they need to receive treatment for their serious health condition, or they can't work due to the condition itself, they're still going to be able to take leave. And it is possible that actually having COVID-19 might qualify as a serious health condition if there are symptoms and those symptoms require some sort of treatment. So just having a positive COVID-19 test, if you're entirely asymptomatic, would not likely make the employee eligible for COVID-19. The other scenario we've already started to see, though, is where employees might be asking for leave to care for family members with non-COVID-19 serious health conditions for various reasons. Maybe they're caring for an elderly parent who can't go to their normal whatever, whether they were in a nursing home, assisted care facility, or just had someone come into the home to help them. If that arrangement is no longer available because of COVID-19 related concerns, and the employee is now wanting to take FMLA leave to care for that family member with a documentable serious health condition, then they would likely have the right to that leave. Now, it's a gray area because it is possible that some of these employees are now suddenly needing to care for a family member's serious health condition, where the real motivation is they don't want to get exposed to COVID-19. But again, if the parent or child or spouse actually has a serious health condition and actually needs care, then the fact that the employee is now choosing to do it when they hadn't previously does not disqualify them from getting the FMLA leave necessarily. And the other thing to keep in mind is this type of FMLA leave we're talking about, again, if none of the state paid leave requirements or the limited federal coronavirus related paid leave requirements apply, would be unpaid leave. So there are some employees who might be able to take up to 12 weeks off for these conditions, but that doesn't mean they're necessarily going to get paid for it. Final point here is the disability accommodations. If an employee asks for an accommodation related to COVID-19, then the employer needs to at least engage in an interactive process with the employee to determine whether there is an accommodation necessary to allow the employee to perform the essential functions of their job, and what that accommodation would be and whether it would pose an undue hardship. There are a few different situations, but the bottom line is, employees with certain medical conditions believed to be at higher risk of suffering severe illness if they contract COVID-19 are likely to ask for accommodations ranging from working from home to some changes in the workplace. Again, this is new uncharted territory for the most part, and we don't know everything there is to know about this virus, but you would at least need to entertain discussions with the employee. If you're in New York City, you have heightened obligations to engage in what's called a cooperative dialogue under the New York City human rights law, which requires a written determination at the end of the process. But don't just blow it off and say, no, if we took this request, then we'd have to take it from everybody. You at least need to actually go through the process. And the latest development, as we continue to wait to see what the state and local governments will do on a day-by-day and week-by-week basis, is the status of unemployment insurance benefits. As most of you probably know, back in March, the Federal CARES Act was passed and signed that temporarily expanded unemployment benefits, that generally expanded them through the end of 2020. It included expanding the list of employees that were eligible to collect unemployment to include people like independent contractors and sole proprietors and people who otherwise would have been disqualified on the basis that they weren't actually looking for work or available to work, including potentially employees who have school-aged children at home and can't find alternative childcare. All of those types of additional coverage issues are still in effect, again, currently through the end of 2020. The piece that recently expired was the extra $600 per week benefit, which was a huge benefit, in some cases doubling, tripling, or even increasing by a larger factor the amount of weekly unemployment benefits some employees received. That did expire at the end of July. So that is off the table at this point. Late last week, President Trump signed a memorandum. It's being reported somewhat as an executive order, but it's technically labeled as a memorandum from the president's office. Not clear whether that distinction matters. It's not clear whether it's legal in the first place or has any effect, but it would offer up to $400 in additional unemployment benefits. So basically where it used to be that $600, now it would be $400. $300 of that would be paid by the federal government and $100 by the states. The states have to opt into this program, and they may or may not have to pay that $100 as a condition to getting the $300 from the state. Based on the money allocated in the president's memorandum, it's estimated that even if implemented, these benefits would only last for another 5 weeks. And I'm particularly dubious about whether this is ever going to mean anything in New York, because Governor Cuomo on Monday called this whole approach by the president a non-starter. He clearly believes, as many people do, that this is not a legal act by the president, and he obviously is not happy with the president because he wants funding for the states, and he's not willing to agree or have his congressional delegation in Washington, to the extent he has any control over them, agree to any further stimulus that is not tied to state funding. So that's just an update on that situation, but I would not assume at this point that that $400 in additional unemployment benefits is going to apply in New York, but I guess anything is still possible. Congress is under continuing pressure to address a lot of further stimulus issues, including unemployment, but as of the latest word, they don't seem to be close, and both sides have seemingly drawn a line that the other won't cross. So with all that being said, we anticipate more to come. Best way to stay updated on a more day-to-day basis, and make sure you're following us on LinkedIn. Horton Law on LinkedIn is where we are able to most quickly post updates, sometimes immediately as soon as something gets announced, other times after we've had a chance to digest it and write it up. We also send out a monthly email newsletter, so at least make sure you're signed up for that list to get a recap once a month on what has developed. With that, and if you need to get the newsletter, you can go to our website, and it's easy enough to find at hortonpllc.com. We are going to now answer questions. I know that a few have come in a couple minutes. I'm going to put the link to the slides for this presentation up. Thanks for sticking with us. I know we're a few minutes past the hour, but again, we will now start answering questions. We'll stay on to answer those as long as they're coming in. And let me just answer a couple that came in towards what I was just talking about, since that was the most recent. Let's see. So the last question I saw was, can I designate an unpaid FMLA any employee who qualify for ESPL? I'm going to probably need help on what ESPL
It's the emergency sick pay.
That still doesn't entirely help, but I'm going to assume it's the federal. Yeah, okay. So the federal emergency paid sick leave, because they're under a quarantine order and awaiting test results. No, probably not, but maybe. So that is a real gray area, because again, just being diagnosed with COVID-19 is not guaranteed to be a serious health condition under the FMLA. On the other hand, seeking treatment for a serious health condition would be. So I think you're going to have to actually wait to find out whether they had coronavirus and or whether they have symptoms. Now, if they already have the symptoms of coronavirus and are waiting test results, then they might be eligible for it. So if they're asymptomatic, I would say no. If they're symptomatic, possibly, but it's not quite that easy, unfortunately. You're going to end up needing the actual medical certification to be filled out before you can then go back and determine whether you can retroactively designate it as FMLA leave. All right. There was also a question I saw about traveling by car and how it will be enforced. You can go ahead, Julie.
So the same thing applies to travel by car, assuming that you're within the restricted state for more than 24 hours. If less than 24 hours, that's fine. But you're right. It's not as easy for them to detect it, but you're supposed to, anyone traveling other than by air, you're supposed to go online and fill out that travel form as well, even if you're by car. But as for tracking it, I think they definitely have some difficulties in doing that.
Yeah, the other note on that is some of the reopening guidance that has come out most recently with the screening component, where you're supposed to have the questionnaire, has included or suggested at least including in your questionnaire whether the employee has traveled to any state listed in that list in the last 14 days. So like when you're asking about have you been near anybody who's tested positive? Have you had any of these symptoms, or have you tested positive? They would, seemingly, although they haven't put it in all the guidance, like you to also ask whether you've traveled to any of these states. It's going to be a problem if somebody did travel to one of these states and didn't report it and keeps going to work, and then there is exposure to other individuals. So I think as an employer, you want to be on top of this and make sure you know who's traveling where. Now, that's not to say your employees are going to be entirely happy about telling you, but I think you can get away with asking them based on the existing guidance. I'm going to real quick. I know we have at least one more question. If you have other questions, type them in. I'm going to go ahead and post the link to the slides. So if you would like those, you can get those. If you're registered for the webinar, you should also get them by email probably tomorrow. That will go back out, but you can get them right now by clicking here.
Scott, would you like me to answer one of the other questions?
Yeah, if you have an answer.
Okay, so one of the questions is, under the New York State paid sick leave, does the family member have to live with the employee, or can they live in another household? So covered family members are considered the employee's child, spouse, domestic partner, parent, sibling, grandchild, or grandparent. It also includes a child or parent of an employee's spouse or domestic partner. So, I mean, I think as long as they're in that, I think it's possible definitely that a grandchild or grandparent doesn't live with them, but if they're taking care of that individual, I would, I think that they're definitely covered. Thought?
Yeah, no, I'm sure that's right. And the same is true under the FMLA. You can care for a parent who doesn't necessarily live with you and still have it qualify as paid family leave FMLA leave. The New York State paid sick leave is certainly cognizant of the FMLA and virtually in all respects and tends to be broader. So again, this is something that might be clarified in the regulations that we anticipate hopefully coming out in the next month or so. But yeah, that's right. They don't have to live with them. I mean, theoretically, even a child wouldn't have to live with the parent. The parent could be going to, the child's house where they live with a, ex-spouse or something like that to care for them during the day.
Mm-hmm.
I'm going to look at this other question. Situation where employee's wife and children are COVID positive and quarantining. Employee is negative. Employee is not working because the family is quarantining. Because his dependents are positive, he falls under the 2/3. Yeah, so the employee in that situation is under a
They're caring for a dependent.
but the question would be, I think, whether the employee is also under a quarantine or isolation order, I guess a quarantine order, because they're exposed. If the employee is quarantining because they have been exposed. I'm trying to think this through. I might have to flip back.
So we're talking about the New York then, right? Not the federal.
No,
they're not asking that.
This is federal. This would be the federal. I know it's really hard, guys. Bear with us because there's so many of these laws and they're so new. But no, this would be the 2/3 new federal sick leave. Let me see. I gotta get back to that slide. Yeah, again, if the employee is subject to a quarantine or isolation order, then the employee would be entitled to 2 weeks of 100% paid sick leave. So let me see. Okay. All right. I see a clarification said this employee is not under a quarantine order. Well,
so
that's kind of interesting. It seems like the employee should be under a quarantine order, but that's not up to us.
Sorry, Scott.
Oh, go ahead.
The second part of that one, though, is there's up to 80 hours of paid sick leave at the 2/3 in order to care for an individual that is subject to quarantine leave.
Oh, yeah. No, clear. The only question here is whether it's 2/3 or 100%. If the employee is not under a quarantine order, but they're caring for a child who is under a quarantine order, then it's 2/3 of pay. I'm just a little unsure why the person wouldn't themselves be subject to a quarantine or isolation order if they've been caring for someone who has been placed under such an order, but that's not up for us to decide.
I
So
think
yeah,
just that
I
she
think
clarified that the employee was negative.
right, right, right.
But
I think that explains it. But again, that shows how case specific these situations are, because if that employee then were under the quarantine or isolation order, even if they were asymptomatic, for example, and even if they hadn't tested positive under this federal paid sick leave, they would be entitled to 100% pay for those 2 weeks. But these are good questions, because this is the type of questions we're getting all the time now. And it's always a matter of, okay, which law are we under? I should note too that there are situations where, and that might potentially be one of them, both the federal and state quarantine, or both the state quarantine leave law and the federal emergency paid sick leave law could apply, but the federal law trumps the state law if they both would otherwise apply. So if the employee is under a quarantine order and both the federal and state law apply to that employee based on the size of the employer, then the employee would get paid under the federal law and not under the state law. But if for some reason they would get less benefits or less time under the federal law than under the state law, which I can't immediately think why that would happen, the state law would kick in to supplement. All right. Any other questions, Julie? Did you see any other questions that we haven't addressed?
no, I think we've addressed them all.
I'll just go back. We addressed it when Julie was talking about the schools, but we had a question at the beginning. No, I know I wasn't necessarily going to answer it, but we did have a question about schools being open, but parents reluctant to send schools. Can they still attend classes remotely? Most districts are making it available for parents to opt out of in-person instruction, which Julie clearly said they could. I was just going to add, since we had the question, that exactly how that works is entirely left up to the school districts. Some are requiring the election be made by a certain date and then that it be binding for a certain period of time. Some school districts are being more flexible in those respects. But I have seen, for example, districts that are saying, let us know by some date, which is generally like this week, that tells them that we want to opt out, and then you're going to be considered to be opted out of in-school instruction until the end of 2020 at least. Others have shorter windows, but so for what that's worth. But again, the state has largely left the details of that up to the individual school districts, of which there are over 700 in New York State. Some of you have enough employees spread out far enough that you could have employees with students in whatever 10, 20, 30 different school districts without too much trouble, and that means that their students are probably under that many different scenarios, ranging from whether they're in school every day to out of school and only doing remote. And then what does the remote entail? Some districts may have set schedules where students are supposed to be in front of their computer or Chromebook for most of the day. Others, it's more flexible and students can get online when they can or do their work when they can. But just so you know, generally, parents are going to be dealing with a whole lot of different situations. And even within school districts, some have varying models based on the age and grade of the children and or even the classes that they're taking. Some classes being offered remote only, other classes being offered partially in person. There are also potential differences for special education students with disabilities who may be in person more or less often than the rest of the students in the same grade. So tremendous amount of potential complexity, and any and all of this could change at any point in time for a whole bunch of reasons. Julie, do you have any other thoughts or comments on that or anything else?
Nope, not at this point.
So again, I'm gonna sit here for another minute or two to see if anybody has a question. If you have a really long question and you're trying to type it in, just hit enter so we at least see it, even if you need to finish typing. Otherwise, our contact information is now up on the screen. If there's something you didn't want to ask here and want to follow up, stay tuned. We will send out emails to anyone who's registered for our next webinars. Our next webinar, like I said, if the regulations come out, could be on the New York State paid sick leave law, and we can get into more detail on that. But anything else could happen, and if it's important and we can get you information timely, we will do that as well. All right, with that, I think we will go ahead and sign off. Thanks for all of you who joined and stayed on through the question and answers, and we look forward to working with you in the future.